Law. Contract law is, under my analysis, I think it's the second most common legal issue that you face after tort law. Even when we start taking a look at employment law, a lot of employment law, whether it's statutory or not, could also fall within contract law as well, when you have employment contracts for professional athletes, for coaches, things like that. So, the keys to contract law: many contracts do not need to be in writing. Now, there are some that need to be in writing, and that's called the statute of frauds. And that says if you have a contract for something over the value of $500, or if it's the sale of land, or if it's a contract by its very terms cannot be performed within 1 year, it has to be in writing. So if you're looking at, for example, a contract for putting on a tennis tournament, if it's going to be just for next year, that doesn't necessarily have to be in writing. But you want it in writing, something like that, so you understand what the terms of the contract are. A written contract provides the best evidence of what was the intent of the parties, what were they trying to accomplish. That's why you want it. Parties can agree to almost anything in a contract as long as it's legal. If both sides agree to something and it's legal, it's perfectly fair. So that's where you have to have a meeting of the minds. You might say, that's ridiculous. Why do you enter into a contract like that? Well, if you put a bet with a bookie and it's a legal bet in Las Vegas, then that's a contract. It might not be in writing. They might not be able to send someone over there to break your legs, but they could say you breached the contract. And then the question becomes, what were the terms of the contract? That's why you want as many contracts as possible in writing. But if you're buying a Coke from a vending machine, you give the money, they give you the Coke, that's it. There's evidence of a contract that you no longer have $1, but you have a Coke. That's all that you have is evidence of the contract. Now, if the machine gave you the wrong one, if you said you wanted regular Coke and it gave you Diet Coke, then the machine breached the contract. But what if you push the wrong button? Whose fault is it at that point? So that becomes a proof issue, and that's why, as often as possible, you want to have something in writing. That only a small number of contracts need to be in writing. Just understand that from the very beginning, because almost every contract you'll see out there doesn't require writing. So you have tons of contracts only if they want some kind of protection. So if you have a contract with a cell phone provider, they're not going to say, oh, we take it at your word, you're going to be with us for 2 years, you're going to pay all your bills and stuff like that. You don't see it with health clubs. They want to have that proof that doesn't necessarily prevent you from backing out. It makes it a little bit more difficult for you to back out of a contract, because then you have a penalty if you do back out of the contract. And you want to make sure that that is there. All right, there are 4 elements to a valid contract. What are the 4 elements? You need agreement, consideration, capacity, and legality. This is like tort law where you have the 4 elements. You need these 4 elements of contract law. So let's go through what are the requirements. Agreement, consideration, capacity, legality. So we have that as a framework. Agreement: offers, one offering something. I offer to clean your car for $10. I'm the offerer. If you agree, you're the offeree. Acceptance: you can either accept or deny. If you just sit there and I offer to clean your car for $10 and you just sit there, is that acceptance? If I say, if you don't want me to clean your car, tell me you don't want me to do it. Well, that is like a negative kind of approach, and the courts don't like that. They don't want it to be that I have to do something proactive to prevent entering into a contract. Entering into a contract is an active kind of activity. So we need to make sure that we understand how you're accepting the contract. Normally it's a verbal acceptance, or it could be in writing. By signing this contract, I agree to the terms of this agreement. That's perfectly fine. With a mirror image rule, what you have to do is you have to mirror what was offered. So just make sure that you do that. Yes, you could clean my car for $10. Then there's no confusion, unless what if I have 3 cars and you don't know which car I'm talking about? Okay, that might cause some confusion. So you have to make sure that there is this meeting of the minds. If I have this huge minivan and you think I want you to clean a Mini Cooper that I also have, that's 2 different cars. If I'm thinking about the small car for $10 and the large car is going to be $20, we don't have a meeting of the mind. So always take a look at, was there that meeting of the minds? And it has to be communicated. You can't go, and try showing money or something else like that. Who knows? You want me to kick your car for $10? You know, what was it that people wanted them to do? That becomes part of this issue. So we often, when people take a look at what is involved, there's this whole concept of offer and acceptance. So what are we taking a look at? Offer. The offer needs to be communicated. It needs to be clear. So what about an advertisement? When you see an advertisement in the newspaper, that is an opportunity to make an offer. That's what it is. And so it's not them guaranteeing something, just that when you get there, you can make the offer to buy it for that price. That's what it is. Now, in order to prevent potential fraud, like when they're selling cars, the dealer has to say what the VIN number is or stuff like that, just in order to make sure that there is no bait and switch kind of activities to avoid fraud. Now, how about a reward? If I say, if you find my lost dog, Toto, I'll give you $1,000. And you find Toto and bring Toto to me, do I owe you $1,000? Not necessarily. What if you're a good Samaritan and you were looking for Toto from the very beginning? And you had found Toto, but you're holding on to Toto to get a reward. And you're just waiting. You kept feeding Toto because you thought Toto was a nice dog and that someone would pay money eventually. No. When you're looking at a reward, is an offer and a valid contract if someone sees and hears about that and acts upon it. So if I say, look at, you know what, I lost my dog, darn it, I'm really upset. And Ryan says, hey, look at it, you know what, I'm a great dog chaser and catcher. I have, you know, this Richard Irwin kind of thing where I can talk to animals. And they sense me and I can really communicate with them. And he goes out of his way and finds the dog and brings him back. Then I owe the money. Because he went out of his way to, in fact, find the dog for me. Versus just if he found the dog on the street one day, said, oh, Gil Fried is the owner of it, and brings the dog to me and never saw any reward poster, never knew about it, I don't owe him anything. So that's why an offer, it has to be communicated. Someone has to know that the offer exists. Acceptance. It needs to be clear. This is where the mirror image comes in. It's the exact opposite. The exact replication, mirror image of what the offer was. So if you modified it in any given manner, it cancels the first offer. And that's the counter offer. And you've got to be careful with this because this could come back to bite you. There are a number of occasions where people come back, and I remember I handled a contract offer and negotiation process with someone. We had offered them, they had won a gold medal at one of the Olympics, and we were authorized by a major chain to offer them a contract to go to several stores to help open the stores and to promote himself there, and likewise to promote the store. And we had worked out the terms of the contract, and then his agent, who was his uncle, said, okay, yeah, so he goes first class, and I also go first class because I have to go with him. Now that was a counteroffer. And my take on it was that that is unacceptable. And so I said, no, we're not going to do that. If you're going along and you want us to pay first class fee to travel, you're not going to come along. We don't want you. That's it. And so we're backing out of this contract. And so then he came back and said, okay, I don't have to go. And I said, look, you're a jerk. I don't want to have to deal with you anymore. The contract is canceled. There's no offer on the table anymore. You just lost out several $1,000s for your client. Simple as that. And that's it. Because if someone's going to try doing that for you when you've already negotiated all the terms, that wasn't brought up, they're trying to throw that in the last second, I don't have faith that they're in fact going to follow what's going on. You know, because what else are they going to try to do? One of the things that people often talk about is the band Van Halen. That they used to go wild in hotel rooms if they had, I think it was green M&Ms. And they had it in their rider that there can't be any green M&Ms in the M&M dish that was supposed to be in the room. And people might be saying, why, those obnoxious stars that want everything, and that wasn't the reason. They want to make sure you in fact had read the rider and all the provisions of the contract, because that's what you agreed to. And if you didn't show that kind of detail, that you in fact read everything and complied with everything, they were not sure that you in fact would comply with anything else. And so you breached the contract by not cleaning up all the M&Ms from the dish and removing all that given color. I don't think they gave a rat's you-know-what about the M&Ms. They might like it, but they don't taste different, okay? I hate to break anyone's idea that the blues taste different than the red. No. What it is that they want to make sure someone, in fact, was in compliance with the contract and they read the terms, because these riders are quite dynamic. And they cover everything. When you have stars coming out, like Barbara Streisand, when she comes to Webster Bank Arena, she has to have her own chef, and that chef cannot be disturbed for a certain amount of time where no one else has access to the kitchen. You have all these bands that will say, I want 3 bottles of cognac, I need Jim Beam, I need this, I need that, and that's what they want. And they want to make sure that the contract is abided by the other side. So that's one of the things, acceptance. When it got accepted, you want to make sure that they in fact comply with the terms of the contract, and that's why this mirror image is so critical, because it's very easy to breach a contract by failing to see one little clause or provision. The mailbox rule, you don't see it that much anymore because of new technology. It used to be that what happened was you went in, you have a contract, it came in the mail to you, it wasn't emailed, you signed it and put it in the post office, this old thing called a post office would actually deliver something called the mail to you, and then you'd get it, and what would happen is, let's say it's in the mail, and I signed it, sent it in the mail, and the very next day I get a letter saying, we rescind the contract, sorry, we don't want to offer it to you. But I already accepted. The mailbox rule says the second you accept it and put it in the mail where it can't be retrieved anymore, then the contract is a valid contract, the other side can't back out of it. I guess the same thing could apply now. If you send someone an email response saying I accept the contract, and then they call you before they get that email and say, oh, we canceled the contract, and you said, hey, look, I sent you an email about 5 minutes ago saying I accepted it, they'll go by that time. And you could take it to court and have the log of when the phone call came and when the email came, and if you accepted before the phone call, it's a valid contract.